Welcome to the Business SOS Podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is episode 124 of the podcast, and I truly appreciate you listening to me for the last 2.5 years and supporting the show. Hope the information that I provide to you is valuable to your business. Last week, I began talking about depositions. So today, I want to continue this topic and review a little bit more what we talked last week. And I really want to spend some time talking about the importance of depositions, especially if you are party to the lawsuit, and why they are important to you, why you need to pay attention to them. When your attorney calls you, say, we have a deposition, your deposition scheduled for this day. Why is it important to prepare and to really pay attention to your attorney in that preparation? Because the deposition can make or break your case. Whether you're plaintiff or defendant, your deposition is probably one of the most important days of your entire case. That's really very, very important. And I want to stress that to you. So we talked last week about what is a deposition. I'm going to do a quick review of that, and then I'll go into a little bit more deep dive into some of these topics. Deposition is sworn testimony. You will be in a conference room, in some cases if it's a live depo, or you will be via Zoom. Now, many depositions are done remotely via Zoom. In fact, I think in the last 5 years, I've done maybe 2 depos that are in person. Basically, all the depos that we've done are done via Zoom, whether I'm representing a client who's being deposed or I'm conducting a deposition, pretty much that have been done remotely. And there's some pros and cons to that. I seem to prepare like the remote depositions. Number one, it's convenient. We don't have to drive anywhere. We can do it from the convenience from our office. And also, we are able to display exhibits with a lot more ease than we actually are in person. So that's really my preference. Everybody has their own. And that's I enjoy it more in terms of how I conduct my depositions. I like remote depositions better than in person. But everybody has their own preference. You as the client, when somebody's deposing you, it's going to be deposed by an opposing counsel. If you're a defense, you're a defendant in the case, you're going to be plaintiff's counsel is going to be deposing you. If you are the plaintiff, the defense counsel is going to be deposing you. The objective of the deposition is to get testimony to be used against you. Okay? Is to gather facts, but to get testimony that will be used against you. And the objective is either for a summary judgment motion or to use it for impeachment at trial. So you have to understand that the opposing side is not there to help you, is out there to get information from you that will be utilized for his client's best interest against you. So I need you to make aware of that, and that's why preparation is very important. The deposition, your answers will be under oath, meaning you're going to have a co-reporter who's going to ask you to show your ID, and then the co-reporter will take an oath, will take your oath, administer the oath, and then the deposition will begin. A couple of rules in depositions. The attorney will probably begin by giving you some housekeeping instructions, and I'll give you some of those right now. Some of those include that when you answer your questions, answer them audibly, so the court reporter can, take the correct transcript of your testimony. If you need a break, just go ahead and ask for the break after a question has been answered. If you do not understand a question, just ask to be clarified or repeat the question. Simply because if you answer to the question, it is understood that you understood the question. It's assumed that you understood the question to be able to answer the question. The instructions may include not to guess, meaning that it is okay if you do not remember something. The testimony that you'll provide that day will be based on your personal knowledge on that particular day. And it is possible that day you do not remember something. So just say, I do not remember, I do not recall. That is fine if that's the truth. If there are documents that might refresh your recollection about certain events, especially now we're dealing with email communication, we're dealing with text messages, we're dealing with documents, you can say, you know what, I don't remember, but there might be an email that might refresh my recollection, or the attorney will say, is there any document that may refresh your recollection? You say yes. And the attorney may produce that document and help you refresh your recollection. Again, the instructions are, if you want to take a break, again, you can give the break. You also cannot speak with your attorney throughout the deposition. This is a court proceeding, even though you're not in court, but it is under the rules of court. So your attorney cannot assist you in any way, shape, or form while this deposition is open. You can talk to the attorney before the deposition or after, but not during the deposition, about topics regarding the depo. If other instructions that I can give you that might be important to you, I'll talk more about those instructions towards the end of the depo, that you will have an opportunity to sometime correct the record. One thing, if you throughout the deposition you remember something, and from a prior question that you did not remember, or perhaps you want to clarify something, you're entitled to do so. It is very common that when you're in the deposition that you may remember something about a prior question because you're already thinking about that. You can say, you know what, I remember something about this other question that you asked me. I said, okay, if I can clarify something. So you'll have that opportunity. And if the attorney says no, your attorney will have the opportunity to, under what is called redirect or cross-examination, at the end of his deposition, to ask you those questions to help you clarify some points. So one of the things that the depositions do and is really to test your credibility and to see if you're a credible witness, and also challenge you on your claims, challenge you on your positions and your allegations. So preparation is important. So how do you prepare? Preparation, the first thing you got to do is be familiar with the pleadings. When I mean the pleadings, if you are the plaintiff, is to be familiar with the complaint, with the allegations on the lawsuit. So you have a copy of those. So you got to read those documents beforehand. In DAGA, you don't have to memorize them, but you got to read them, be familiar with them. Be familiar with the allegations that are made. Your attorney is the one that drafted the lawsuit based on the information that you provided to that attorney, to your attorney. But it's important to read it because the attorney on the other side is going to ask you questions about the specific allegations in that lawsuit, or if you're defending that lawsuit, on the specific statements that you made in the affirmative defenses or your denials. So understanding what the lawsuit says and also understanding what defenses you're raising are very important. You got to read your answers to the discovery. In most cases, or in many cases, in my experience, by the time you have a deposition taken, you already have answered some discovery requests. Discovery requests are interrogatories, requests for production of documents, and a request for admissions. So, we talked about discovery documents in prior podcasts, but I'll just briefly tell you what they are. Again, request for interrogatories, exactly what it means. You will have a list of questions that are provided to you, and you're going to answer those under oath. Your attorney will assist you in making sure the answers are correct, but you're going to provide those answers. And it's going to go through various drafting processes, and then at the end, you review those answers, and then you sign them under oath. Those are the interrogatories. Requests for admissions are what it means. Okay, they're going to ask you to admit or deny certain statements that they will provide to you, And most of them you will probably deny because if you admit to whatever they're asking you to, you pretty much lost the case. So most of them will be denials, but they will ask you about those. And the other one is request for production of documents. And the request for production of documents is exactly what it means. You're going to be given a list of questions by the other side to produce documents, and those documents may include contracts, may include statements, may include text messages, email communication, voicemail, videos, whatever media is available regarding the case that might be in your custody, possession, or control. So all that information, all that what is called discovery responses, you already have provided to the other side. And it's usually your depo might be a few months later. So you're not going to remember everything that you provided to your attorney to provide pursuant to the responses. So it is important that you review the answers to your own interrogatories, review the answers to the request for admissions, and review the answers to the request for production of documents. Because this is what's going to happen. The attorney is going to specifically ask you, let me backtrack a second. When you review those documents, okay, and review those answers, if there's any changes to those answers from the time that you provided those answers to your attorney to the time that you are reading them in preparation for your deposition, let your attorney know beforehand. Because the attorney can make what is called make a supplemental, an amended answers and correct whatever mistakes were made or corrections or any type of addition that has to be made to that answer to the interrogatory. And it's better for you to do that before the deposition as opposed to be confronted with any type of contradiction at your depo. And that happens often. Sometimes people write in, and that's what they recall at the time. And then, when they're preparing for the depo, say, I remember, you know what? This particular answer is not exactly the way, it should have been written. And you told that to your attorney, and then your attorney can do an amendment to that particular interrogatory and submit it to opposing counsel. Of course, opposing counsel is going to ask you about that change, and that is fine. But you're better off coming forward with that change as opposed to having a confrontation or a challenge to that based on newly discovered evidence that was not available at the time. Request for production of documents. It's very common that when you provide your documents to your attorney, that some documents perhaps were not found at the time, you do not remember that they were available, or in some cases you don't think they were important. If there's email communication between you and the other side already has it. So review whatever you provided to your attorney and make sure that you provided everything that was asked for. Okay? Because what's going to happen is this. If you did not provide every information that was there, the other side is going to ask you why this document was not provided or why this document was omitted. So your attorney should know that in advance as opposed to be surprised at the deposition. Has happened to me many times. So it is important to tell your attorney, listen, I don't think this document, there's something missing here. That's the first phase. Make sure everything is completed. It should have been done beforehand. We're human. Sometimes it happens. Sometimes things are missed or things are not found initially when you look for them, especially if we're dealing with a deadline. But you had, in Florida, in most jurisdictions, you'd have, especially in federal court, you have a duty supplement. If there's anything that was asked at some point, you later find out something that would answer that request, you have an obligation to provide it. So you supplement. It can be resolved. Then you go in and reviewing the documents that you provided themselves, the content of those documents. If there's email communication that was provided, then you need to review those emails. Review the context of the email communication. Review the text messages that were provided. It's important for you to look at that because you're going to be asked about those. Make sure, and your attorney will have to make sure that every single document is Bates number. So that when there's a code, there's some type of number, unique identifier to that particular document because you're going to be asked about that document. It is not good when somebody presents you a document that you have received, that is show clearly an email you received or a letter, and then they present it to you and ask you, have you ever seen this document before? You said, no, it's the first time I saw the document, or I don't remember. So it's important to prepare for that. So I was talking about a request for production of documents and important for you to review every single document. Also, by that time, you probably have received documents from the other side because your attorney most likely have also requested documents and interrogatories from the other side. You should review those as well because usually those documents complement each other and the answers complement each other, or sometimes there'll be contradictions. So it's important to be familiar with not only the documents that you provided to them, the documents that they provided to you, because you'll be able to determine also whether documents are missing. So you see how preparation is important. Requests for admissions are what they are. Review your request for admissions. Most likely, unless it's something very self-explanatory that you admit, most likely there will be denials, but cover those with your attorney as well, because they're going to go over that. Your attorney also will prepare you on the types of questions that you can anticipate. The attorney will take the role of the other side and say, these are the types of questions that you can anticipate, so that way you're prepared to answer those questions. If there's anything in your potential answers that you feel may not be beneficial to your case, or perhaps it might be more, I think a better term would be prejudicial to your case, discuss that with your attorney beforehand. Discuss that, say how I'm going to handle this particular issue, and that's where the preparation comes in. That you can discuss that with your attorney, and then the attorney can assist you in how to handle that. You always remember you have to answer the truth. That's very important. Understand why you're suing if you're the plaintiff. Understand what your defenses are if you're the defendant. A lot of the contracts that I handle deal with primarily breach of contract claims. But understanding the contract, especially if it's a contract claim, is very important. Not from a legal perspective, but from the factual perspective. What one party was supposed to do, what were the obligations, what one party was supposed to receive, where was the breakdown. So that's important to understand. It's important to prepare emotionally for your deposition. And what do I mean about that? The depositions is an intimidating process. You are, in essence, on your own, and you have somebody that is an opposing side that is going to be asking questions on their oath. And you don't know what questions they're going to ask you. And you basically are, for the lack of a better analogy, in the hot seat. So it's not a pleasant process. But it's important to be professional and not be confrontational with the attorney. The attorney on the other side is doing his or her job. And that's what we do. So the more professional you are, the better. The more prepared you are, the more relaxed you're going to be. I'm not going to tell you here that you should be relaxed in your deposition. That would be unfair to you and to anybody who has a deposition taken. But the better prepared you are for your depo, the more confident you're going to be in your answers. So that's why preparation is very important, because it's a very important day for you. Next to trial date, I think the deposition is one of the most important dates that you will have in your case, and then I will follow that by mediation date. Those are three key dates that are or events in your case that are extremely important. So it is your day, and it is your day to. The more prepared you are, the better you will be. Opposing counsel may be confrontational with you and try to intimidate you. Again, your attorney will be there if there's something that goes out of hand. So here, the attorney will have tools available to protect you. We have objections that we can raise in the event, and in the event there's a question that is asked that is that you have some privilege, that will be raised as well. If there's an issue that the attorney is a little bit too aggressive, your attorney can go offline and talk to the attorney to tone it down. So there are things that we can do to keep the deposition professional and factual without getting confrontational. But from your end, especially now that it is so easy and affordable to take video depositions, your demeanor, how you look in the video, how you sound, is very important. It's actually as important as what it looks on the transcript. So when you're answering the question, answer factually without any type of confrontation, or don't try to second guess the attorney or be a smart ass to the lawyer. It's just not going to work. Okay, it does not look good on video. It does not sound good. It might put your attorney in a difficult position as well. So just try to be professional, factual, and just get through it. The more professional you are, the more factual you are, the shorter the deposition. When you become confrontational, you become belligerent, you refuse to answer questions that even your attorney cannot object to, it becomes more problematic and it makes it a longer depo. So let's talk about that for a second, about not answering questions. The only time that you do not answer questions in a deposition is when your attorney specifically instructs you not to answer questions. There might be reasons for that. There might be reasons for privilege. If they ask you a question, what do you tell your spouse last night about the case? Well, that's a privilege. You have the privilege, marital communication privilege. That's a question that you don't have to answer. Your attorney will say, you're not going to answer that question. I'm just giving you one example. Okay? There may be, and now, again, when that happens, there will be other example, not as obvious, that your attorney may ask you not to answer the question, and for whatever reason. So the attorney will, in this case, certify the question and then present that question to the court and ask the court to compel you to answer the question. And then the court will determine whether or not that will take place. Your attorney also may object to some questions. That's very common. Even if the attorney objects to the question, you still got to answer the question. So just because you have a transcriber, a court reporter, when a question is asked, even if you know the answer, you just pause for 2 seconds so the attorney can decide whether or not the attorney wants to object to the question or not. Don't just go straight to the answer. Also, when the question is asked and you know the answer already, don't try to answer the question before the attorney finishes his sentence, simply because the court reporter cannot properly transcribe two people speaking at the same time. If you have to give some thought to the answer to the question, give it some thought. Some of the questions that I might ask you, you might actually have to think about because you don't have the answer at the top of your head. It's okay. So let me think about this for a second, and then you can answer the question. So, and the same thing with documents. If documents that are presented to you, If you need to review them for a minute or two, you can say, I want to take a look at this document before I answer the question. And that is fine. Another tip that I will give you is not to bring documents to the deposition unless you're instructed to. And I'll give you an example of that. Sometimes there are depositions due tecum, which has a list of documents you got to bring to your depo. Frankly, I don't like those simply because you're bringing documents at the depo for the first time, and then people have to, how are you going to organize those documents and have them ready for the depo on the same day? That should have been done on discovery. Otherwise, do not bring any documents. Your cell phone should be turned off during the deposition. And I've seen examples of people making mistakes in depositions that they have their phone next to them and they decide, they ask a question about a specific email or event and say, hold on a second, let me look at my phone. I have my emails here. Let me look at them. When you do that, you're opening the door to they're going to say, hey, you did not provide all the documents that you were supposed to provide. Number two, I'm going to ask, we're going to put a request to have the phone imaged or download, be able to look at your phone and look through your emails because you did not provide all of them. So your phone should be off. There's no communication with your attorney throughout the depo, including text messages. And also not looking at your phone during the deposition. If you have to have it on, have it in your pocket, then during the break you can look at it in the case of any important messages. That is fine. Family members or what have you. But the less you don't have anything on your deposition, you don't have to write notepads, nothing. Just go yourself and answer the questions. Because even if you take notes, those notes can also be requested to be produced. So that's my suggestion. Don't bring anything to a deposition unless you're specifically asked to bring them pursuant to a ducis tecum, and your attorney will tell you whether or not what you can bring or not. I would avoid sarcasm, frustration, arguing. Don't ask questions. Don't get belligerent with attorneys. It's not going to be helpful to you. Okay? Common mistakes that people make in depositions. I want to also talk about that. One of them is talking too much. Okay? What happens is that people sometimes, they don't listen to the question well, and they go into long narratives. And they end up opening other doors of inquiry that were not planned in the first place. Happens to me every time in my depots when I'm conducting depositions. I have my outline that I want topics that I want to cover, and pretty much every single time I have to deviate from the outline because something that was said by the deponent that opened a new line of questions. So it's important to listen to the question, answer the question truthfully and fully, but just don't keep expanding into other areas that may not be related. Guessing or filling the gaps. The answer should be, your answer should be based on your personal knowledge at the time. No guessing. If you do not know the answer, don't guess. Don't say, I'm guessing, or no. You do know or you do not know. It's black and white. So people sometimes try to guess, and it becomes an issue. Again, I mentioned bringing notes or documents that you don't have to bring. Getting defensive or arguing, I went over that. Don't get defensive or argue with opposing counsel. Again, if the attorney's trying to ask the same question several times, which happens often, your attorney will address it with the attorney through an objection, or we'll discuss it with the attorney that the question has been asked and answered several times. We will move on. Okay? Because sometimes they're trying to get you to do a specific admission that they're not getting on the record. It is very common. not listening carefully. And this is very important. It becomes important towards when you're going to hour number 2 or 3 of your depo, even 4, that's where the most mistakes are made. People are tired. People have gone through a lot of answers. And it's important to pace yourself. It's important to listen carefully to the question and answer the question. It will make the deposition smoother. Trying to outsmart the lawyer happens very often. People try to do that. All right. The attorneys who do this for a living are professionals. They know how to ask questions. They know how to listen. You're not going to be able to outsmart the attorney. Don't try. Okay? Just be factual about your answers and let the record speak for itself. A good record is helpful to you. A bad record is not helpful to you. So don't try to play this game trying to outsmart the attorney, because the attorney is going to continue asking the questions, and eventually he's the one in charge, not you. And if you don't finish that depo that day, it'll continue for the next day or another day. So those are the mistakes that people make. Now, let's talk about the end of the deposition. At the end of the deposition of the attorney who's deposing you, your attorney will have the opportunity to do what is called a redirect or a cross-examination, meaning there might be areas that he may want to ask you that for clarification. In many cases, I don't do crosses. Sometimes I do for a specific point because the other side has the opportunity to redirect. Because that's going to be on the record. But he has the opportunity. If there's no cross-examination, then they're going to ask you whether you want to read the transcript when it's ordered or you want to waive your rights to reading. What it means is this: you can read. You have 30 days to read your transcript and to see if the court reporter properly transcribed your answers. You're not going to change your answer. Simply might be a name that is incorrect or some item, but you'll have the opportunity. You'll be given what is called an errata sheet that you can write the specific items that have to be corrected. The other side will review it, and the other side has to write. If it's something that is significant or material change to your answer, he has the right to recall you to go over that particular change. Or you can waive it and say, no, I believe the court reporter transcribed my answers correctly. I don't need to review it. Okay, your attorney will review that. We'll discuss that with you. As I mentioned before, deposition testimony is often used to impeach you if you contradict yourself, frame the issues for summary judgment as well, and also develop the themes for trial. Usually, it's very common that after a deposition, there's a lot of things change. It could be something on your favor, something against you. So it's important that your attorney debriefs you about how the depo went, and then tells you, okay, we have very strong points here. This really did not work well for us. We'll address it in a different way. But your attorney will debrief you about your depo, and then your attorney also will have the opportunity to depose the other side as well. The more preparation you have in your deposition, the better you will be. I think this is good for today. I hope this information was helpful to you. And again, this is not legal advice as to your particular situation. These are simply topics and suggestions that I think might be helpful if you are in a situation that you are deposed either, as a party, whether a defense or as a defendant, but also as a witness as well. If you're deposed, if you're subpoenaed for a deposition as well. If you have any questions about any of the topics that we covered, if you have want to send me an email, my email is rich, R-I-C-H, at richsierra.com. Again, it's rich at richsierra.com. If you want to learn more about our legal services, my website is floridasmallbusinesslegalcenter.com. Again, floridasmallbusinesslegalcenter.com. If you want to watch this podcast in video. We're on YouTube. We have a YouTube channel. It's youtube.com/@RichardSierra. If you want to give us a call, my number is 866-842-5202. If you want to get a copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, it is available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.